Good afternoon. Stephen Shackelford for the plaintiffs, the Moore Charitable Foundation and Kendall JMAC. Could I please reserve 2 minutes for rebuttal?
Yes.
May it please the court. I want to start with a simple but important point. What you saw in the briefing from PJT, and you likely will hear some in argument today, are references to things like the risk-free return, other reasons why PJT believes that plaintiffs, my clients, should have seen this coming. They should have known they were being defrauded. I want to make sure I emphasize all those arguments have nothing to do with the two legal issues before the court today, the first of which is a purely legal issue, which is the extent of the duty that PJT owes to non-negligently supervise Mr. Casperson. And the second issue is the adequacy of the pleading, whether we've sufficiently pled that that PJT had knowledge, knew, or should have known of the dangerous propensities of Mr. Casperson to potentially defraud potential clients, such as the plaintiffs in this case. Neither one of those has anything to do with the reasonableness of plaintiffs' reliance on Mr. Casperson's representations. That's an issue that's not before the court. The two issues, I'll start with the second one, which is what the court was very interested in when we were here a little over a year ago, which is what did we allege that at the pleading stage fairly indicates that PJT knew or should have known of the dangerous propensities of Mr. Casperson to potentially defraud clients or potential clients. We allege four things, and we allege that PJT knew all four things. One, PJT knew that Mr. Casperson, a high-ranking executive who PJT sent out into the world to be a one-on-one contact with potential clients and potential limited partners, knew that there was a missing $8 million fee, and he told a bald-faced lie to explain why it hadn't come in.
But did they know it was a bald-faced lie? You told them it hadn't come in yet, right?
He told them it hadn't come in for a specific reason, and we allege that they knew it was a lie because it was an obvious lie. He told them that it had not come in because there was a stub closing on the deal.
But isn't it normal in a stub closing, you'd get some of the money, some of the fee, and then after the stub closing, you'd get the rest of it, right?
Exactly, Your Honor. And we allege...
That's what you're alleging, that's why they should have known, not just because he said that, but if they had inquired further that they might?
Well, we allege they would have known that was a lie because they would have known that most of the fee would have come in, and they also would have known that...
I mean, probably many of us have practiced, and you don't get a fee, and, sometimes you get an email or call from a CFO in your firm, or, fee hasn't come in. What, and a lawyer, or in this case, this person says, it's delayed. What is the firm supposed to do at that point?
Well, Your Honor, it'd be one thing if Mr. Casperson had just say it's delayed and given no explanation. But as we allege, and as must be accepted as true at the pleading stage, what he told them was it hasn't come in yet because there's a stub closing, and none of the fee will come in until the stub...
Just to be entirely accurate about that, what you're really saying is what Judge Smith said, that they should have known that that was an impossibility or a lie, not that they actually do, because there are stub closings and sometimes fees are delayed. It's just that your allegation here, or the allegation in your complaint is that because he told such an easily revealable falsehood that they should have known that something was amiss, right?
I mean, technically, Your Honor, we alleged in paragraph 35 that they knew or should have known that it was a lie. Now, obviously, at the pleading stage, we can't get inside their head. But we do allege that they knew it was a lie because the people he was reporting this to knew there was no stub closing on the deal, because there wasn't, and knew that even if there were a stub closing, part of the fee would have come in.
Does it matter who he told that lie to? In other words, could it have been a person who wasn't very familiar with the deal, just was, in the accounts receivable department or something like that?
Well, theoretically, Your Honor, that's a possibility. Of course, we don't allege that he told someone who didn't know what was going on with the deal, and someone in the accounts receivable department at PJT would, at least we're entitled to the inference, they would know how these stub closings worked.
So it's enough for the pleading stage just to say.
And it's just one of four, Your Honor. I mean,
what are the other ones?
The other four, number two, is that when the fee came in, it came in from his personal account that he had disguised. It did not come in from the client's actual account. And we allege, and this is in paragraph 47, that PJT either did not discern that the funds had arrived from the wrong account negligently or did detect the anomaly but ignored it. It's a big red flag if you get money from $8.1 million and you know it didn't come from the right account. So that's a second big red flag, and we allege that they knew that it came from the wrong account. The third big red flag is that Mr. Casperson We allege before the fraud occurred, consistently came into work completely drunk, having drank 10 to 15 alcoholic beverages over lunch, over long lunches, and he went to meetings completely drunk.
Does that in any way infer that he would do what he did? I mean, he was drunk, but that doesn't mean that he's got a propensity to commit fraud, correct?
Well, Your Honor, by itself, we would argue that it still does. At least at the pleading stage, you can infer a propensity for a high-ranking executive who was sent out to deal one-on-one with prospective clients and current clients, that it does indicate a propensity to commit fraud. And I would just point to the U.S.
Are you arguing that someone who has a substance abuse issue or some kind of alcohol dependency issue is automatically subject to criminality because of that disorder? Is that what you just said?
Your Honor, I think it depends on the circumstances and the position. I will point out that the U.S. government,
High-ranking substance abuser.
the U.S. government, for instance, if it's putting someone in a position of trust to see classified documents, for instance, that's one thing they look at. And that can disqualify you from getting a position of high trust.
Doesn't mean you're selling secrets to Russia, does it?
It doesn't, but it means that there is a risk. There is a propensity for that to happen. Same thing with the gambling problem, which in effect is what we allege Mr. Casperson had. He gambled on options. He gambled on personal security trades.
So your answer to Judge Singh's question, I think, is yes then? If someone has a substance abuse issue, that's evidence of propensity to commit fraud?
If someone has a serious enough substance abuse issue and their position is that they deal one-on-one with large amounts of money with prospective clients or current clients, then it at least raises a risk that requires the employer to look into it. To be clear, we have all four.
That's what I
So-
was just going to ask you. So, but do you think if you just had the alcohol issue and his personal gambling issue, do you think that that would pass muster? 32 level?
Respectfully, Your Honor, I do think so. If you look at, for instance, the U.S. government, the U.S. government would not put someone with those very serious
But
problems.
we're not looking at the U.S. government.
Well, this is a sophisticated financial institution with obligations for senior executives. I think that would also, those two things would be sufficient.
Well, the gambling issue certainly, the alcohol abuse, certainly, that might be of a different caliber if it stood on its own, but the gambling issue, although, again, someone who needs help, and, but nevertheless, it does perhaps, as you say, raise at a minimum a red flag to inquire.
Yes, Your Honor, to inquire or at least to better supervise. I mean, to be clear, number one, we have all four of these at the pleading stage, and discovery will show what they were aware of.
And you are emphasizing that it's at the pleading stage for what reason?
At the pleading stage, Your Honor, well, we've pled four different things, which in combination certainly give rise to the inference that PJT knew or was on notice of these dangerous propensities.
And how, at the pleading stage, how is this to be considered by the court? When the motion is made, since it's the 3211?
Yes, Your Honor. Well, we are entitled to all reasonable inferences, and we're entitled to acceptance of all of our allegations are true, whereas at the discovery phase, if we get past the pleading stage, we may well see in discovery that they had internal records of this. They may have policies, for instance, that say if someone has a substance abuse problem, we have to watch them more closely.
Counsel, could we just, I see your light is on, but with the Chief Judge's permission, if we could just explore the other issue a bit. One thing I'm struggling with is if we go the way you want and you get that result here, where does this stop, right? And the appellate division seems to have put in this rule, in its ruling, that because, you know, this person, you weren't a client of the firm, right? There is no duty. And so to get at that issue a little bit, I'd like to ask you about a case. They relied on a case called Gottlieb v. Sullivan and Cromwell, right?
Yes, Your Honor.
Law firm, employees, insider trading, gets sued by someone in the market who's injured supposedly by that trading. And the second department, I think it is, in that case, says plaintiff was not a client of the defendant, with the result that in the absence of privity, the defendant owed no duty. If we go the way you ask us to, if we rule that way, would this no longer be good law? Gottlieb v. Sullivan and Cromwell.
Gottlieb would still be good law, because the rule we're asking for is for prospective customers who deal with the tortfeasor in connection with his employment. And Gottlieb,
I would assume that you're saying that what you're expecting is that there's some type of nexus between the employer and the prospective client, or even if it's not a prospective client, but to the injured person.
Yes, Your Honor, some nexus between the injured person, the employee, and the employee's
The
job.
nexus.
Here, the nexus was the reason why Mr. Casperson initially...
What's the rule if we do this?
So there are two different answers for that, Your Honor. One, the rule we espoused and we argued for is for a prospective customer who deals with the employee in connection with that employee's employment, or who deals with the employee because of his employment.
Let's say employee of a brokerage firm and is running a Ponzi scheme. And, I'm an employee of Jones Brokerage, and come on, and you can invest your money. It's a completely separate Ponzi scheme going out and trying to find small, investors that they can take advantage of. And Jones is a big brokerage house that has, pretty much institutional clients. That case.
So if I understand, Your Honor, if the brokerage firm has sent that employee out into the
No, they're
world...
sending them. They're sitting in their office. And they're a broker. They're sitting in their office. They have institutional clients they're servicing, but they're going out and they're recruiting investors to invest in this fund, which doesn't exist, a Ponzi scheme, but they're answering the phone in their office, and maybe they're using their email or they're using their office phone.
So yes, Your Honor, the rule on those facts would cover that circumstance because that employee has been authorized by the employer to reach out to prospective customers, which is part of his job, but he reaches out to prospective customers acting as though he was doing it for the benefit of his employer, but he's actually running a side Ponzi scheme.
This might be the same question, just asked a different way. But if the defendant, the brokerage in this hypothetical, has no idea that the plaintiff is out there, that this person is doing their Ponzi scheme independently, is that still a prospective customer under your definition of that term?
It depends on who he approaches as a prospective customer. If he's approaching, let's say it's an institutional brokerage that only deals with companies, and he's approaching individuals and saying, and it's not part of his job at all, then theoretically in that circumstance...
Well, let's say it's this brokerage, the plaintiff, the defendant in this case, and your entity, the plaintiff in this case.
Well, in this case, the initial approach, and this is at page 11, note 7 of PJT's brief, the initial approach was made to More Capital, and More Capital is obviously a legitimate prospective customer of PJT, both as a prospective private equity company that could come in to do a secondaries transaction, and as a prospective limited partner to come in and participate in a secondaries transaction.
So it would extend to someone who, under the business model of the brokerage, could be a prospective customer?
It would extend at least that far, Your Honor, but there's one other way I'd like to propose it. In the trial court, we also asked for respondeat superior claim. It was thrown out, but the trial court found that Mr. Casperson had been acting within his scope of employment, but respondeat superior did not apply because he was acting for purely personal reasons. There's a lot of case law on scope of employment. It's a two-part test. It's how the parties approached it in briefing below. Certainly in a case where an employee is acting within his scope of his employment, but for purely personal purposes, you can't have respondeat superior, but the employer has a responsibility to non-negligently supervise an employee whenever they're acting within the scope of their employment.
What was your fourth allegation?
Fourth allegation, you're right, it was the drinking, it was the trading, it was the
Stub closing.
the stub closing, and it was the fact that the money came from a personal account, not from the legitimate account. Thank you.
So the drinking was the fourth, thank you.
Thank you.
Good afternoon, Your Honors. Aidan Sinnott from Paul Weiss for the respondents. There are actually three legal issues here. The first was one that was raised by Judge Garcia in the argument the last time around. There's a Hecker problem in this case. The appellate division decided this case on two independent grounds. One was that there was no duty to the plaintiff here. That is an issue that was not preserved in the trial court, and the appellate division reached it in an exercise of its discretion.
Well, why do you say they reached in the exercise of discretion? Is there anything that could have been done? Isn't that really just a question of law?
But it's an issue of law that was not reached by the trial court and not preserved in the trial court. The appellate department reached it out of an exercise of its own discretion, and under Hecker, this court...
They didn't say that, right?
I'm sorry?
They didn't say that's how they were reaching it.
No, they said that it was an issue presented on the papers, that it was not decided by the trial court, and they were going to reach it themselves.
And
They
in
didn't
their
have to.
department, they had a rule that there had to be a pre-existing relationship. So what could have been offered by the plaintiff in response to that?
Well, the plaintiff did actually brief that issue, right, because we did raise it in our reply brief in the lower court, and we raised it on appeal in the appellate division. Plaintiff's answer was there was enough of a relationship here. The appellate division decided that was not true. It did that in the exercise of its discretion. So under Hecker, this court does not have
So
the
you
power to reach that issue.
assume that, you acknowledge they didn't say they were exercising their interest of justice jurisdiction, correct?
They did not use those words, but many of the cases decided under Hecker don't use those words either. where
And
the-
there are exceptions to the preservation rule, though, are there not?
There are some exceptions. I don't think there's one that applies
And
here.
if there are no counter steps that one could have made, that is one exception. You simply say it doesn't apply here.
I don't think it applies here.
Okay.
No.
But if the rule that they're asking for is, at least in part, from what I heard, that the duty would extend to a prospective client within the ambit of their type of business, isn't that something you could respond to?
I think we could have responded, certainly, and I can respond here. I mean, I think the law from this court is clear. If the damage is purely economic, there is no duty to somebody unless you have a special relationship. And here, there was no relationship whatsoever. The only connection here was between Casperson and his friend, who he reached out to. He offered a transaction which was not of the kind of transaction his employer offered. He did not take money for the employer. He took money for a special purpose vehicle, which he created. That's the same vehicle, by the way, which paid the fee to PJT, which my friend here says was suspicious when it came to PJT. But the fact is it had a name of the entity for the supposed transaction. It was an Irving Place entity. And PJT had never been paid by Irving Place before because this was the fee for the deal. There was no way for it to know that the fee was coming from an account that didn't belong to the entity in question.
Well, that sounds sort of facty to me, right?
Well, I think it relates to whether they were on notice. I think, to finish on the duty point, I think this court's decision in Madison is clear that unless there's a special relationship, there is no recovery for an economic damage. And there was no relationship between PJT and More Capital, and certainly no relationship between PJT and the charity that made the investment. To go to the question of whether we were on notice of what Casperson had done, which is a legal issue. These are elements of the claim. It's not a facty issue. You have to plead facts that show that we knew he was likely to commit fraud. And the complaint doesn't do that. Just to take them in turn, that he was drinking at work. First of all, the complaint is very vague on whether anybody knew that. But second, there are a lot of honest drunks out there and a lot of sober crooks. It tells you nothing about whether somebody is likely
Yeah, but
to
his
take
argument
money.
was standing alone, it might not.
I'm going to take all
But it's
four.
all of these together, so why don't
I'm
we
gonna
work
take
from
all
that
four.
position?
There's also no allegation that anybody at PJT actually knew he was gambling. The allegation in the complaint is he checked his BlackBerry or his phone obsessively. Everybody I work with does that. There's no evidence that anybody knew what he was checking. Third, he said that we knew the fee, or we should have known the fee was stolen. That's not what the complaint alleges. I put together a list of the allegations about the fee. In paragraph 20...
Does it matter that the case was at the pleading stage and how it was to be viewed in the light most favorable to? Does that matter at all?
I don't think it matters on this issue. The requirement is to plead facts that show we knew we had a propensity to steal. If we didn't know what he was doing, we couldn't have known he had a propensity to steal. And here, it's even worse, because what they want to do is make inferences that he was committing fraud on customers from the fact that he engaged in other kinds of risky behavior, like drinking and gambling, which we should have known
So your
about.
position at the pleading stage is that any complaint that alleges that the defendant knew or should have known would be on its face insufficient?
Yes. That is a legal
Every
conclusion.
complaint?
Every complaint that says that would be insufficient, and we cite many, many cases that say that. You have to plead facts that show
But if
we
he
knew
says
or
he
should
comes
have
in
known.
consistently drunk at lunch, drunk at other times, goes to meetings drunk, it was obvious to everyone, those are all factual assertions. Now, you on
agree.
the jury might not agree that gets you to knowledge, but they're
That might
factual
be enough
assertions.
to allege that he drank. I don't think that
That
alleging
they were
he
aware that
drank,
he was drunk.
it might be enough for that. That is not a sufficient pleading to indicate that he was
Yes,
dishonest,
but
as I
again,
think
he's
we've
got
agreed.
more than one, right?
So let's talk about the allegations about the fees. Paragraph 28 says he was able to take it without detection. Paragraph 29 says we failed to detect. Paragraph 39 said that the failure to detect the fraud was negligent. Paragraph 49 says PJT negligently failed to discover the theft of the other fee. All of that says, the facts say we didn't know what he was doing.
But
So we did not.
Should you have known?
Should we have known? I don't think that counts. I think the case law requires you to know of facts from which you should have concluded he was likely to commit fraud.
That's probably what the case law requires at the summary judgment stage, but is it not sufficient to allege in a pleading that he committed this? Let's stick with the stub fee, because to me that's the most damning of the allegations, that he told a patently incredible lie, and they failed to pick up on it. Doesn't that get you through for pleadings? And if it's not, what should they have said?
I think if he had said that to the CEO of Park Hill or PJT, maybe that would be enough. That's not what the complaint alleges. The complaint alleges says the back office people came to him and asked, as back office people do, when is the fee coming in? And let's talk about the timing here. The transaction in Irving Place
That
closed
does
in...
not beg the question whether as a legal conclusion that fact would have been enough to put you on notice, because you don't really know the hierarchy and how it works in the office.
I know what back office people are. I mean, we have them at law firms all the time. I get questions all the time, as I think you did when you were in private practice,
Yeah,
about
but
when
I
is the
have
fee
to say
coming
that
in.
I would rely on my back office people at Cravath to see that a transaction was irregular and a check came, I wouldn't even see the check.
Well, but
So-
you...
But again, Judge Rivera was pointing out, these are really kind of fact issues about how this business ran, who the particular people were that this information went to, and what their responsibilities were, none of which we know.
Well, we do know what the allegations of the complaint are. The complaint says back office people. We know what back office people are.
Well, I don't know what they are.
I-
I don't know what their responsibilities at this company were, as opposed to the CEOs. I would doubt the CEO is getting the checks.
I'm sure the CEO is not getting the checks,
Yeah,
but the
I've seen the wire
CEO might
transfers, right?
understand whether there was a backup transaction or not. And also, let's just focus on the timing. The transaction closed in August. The inquiry from the back office people came, I think, in October, and the fee was paid in November from an account with an Irving Place name. That is not sufficient to put somebody on notice that one of their partners is stealing from the firm. That's what happens at every firm all the time. I would be a hero if all my clients paid their fees within 3 months.
I want to go back to the Hecker issue. Isn't this case different from Hecker? In Hecker, the issue wasn't raised at the trial level, and there was no preservation exception offered by the court. Isn't that different from this case?
I don't think so. I mean, we raised the issue in reply in the trial court. They argued that was too late.
But in the court's ruling, the court said it was ruling as a matter of law as opposed to saying that the court was rendering a decision based on I'm sorry. In this case, the court said that it was basing its decision on a preservation exception.
I don't think that's quite what
Not
it
in the
said.
interest of justice. It did not say interest of justice.
It didn't say either.
Correct.
No,
It
it said
decided
this
to reach-
on the law.
Is it on the law?
Right.
So there's nothing on the law which would take the interest of justice out of that. It would be an exception, because there's nothing anyone could have done that would change that.
But that's not that different than Hecker, where the court decided to interpret a provision in the statute which had not been argued even.
There is something, though, that wouldn't you agree, that seems a little unfair about this, in that you raise an issue in your legal issue in your reply brief. Supreme Court says, I'm not going to consider that. The appellate division considers it, says on the law, you win, and then we're disabled on your theory from being able to to review that.
Well, that's exactly what Judge Smith said in his
That's so-
dissent in Hecker, suggesting Hecker should be overruled, but the court did not accept his invitation there, and in at least 2 cases since Hecker, the court has applied exactly the same rule. So the court could, I suppose, look at the Hecker rule and decide whether it makes sense. I think Your Honor, in a dissent, said that it would require a legislation to change the rule. But if Hecker applies, you can't reach this issue.
But the court could decide if there is no, it wasn't raised, either whether there was an exception, if there was a preservation exception that was offered. If there wasn't, this court could conclude that it was the interest of justice and still be consistent with Hecker.
I don't think this court has the power to decide the case in the interest of justice.
No, certainly not in the interest of justice. That is reserved only to the appellate division.
Right.
We're just, in this particular instance, they invoked it.
They did.
They did not invoke the interest of justice. They invoked an exception to the preservation rule. Certainly, if they said interest of justice, you're right. There's no review here.
But I think that's what they were doing.
By
They
saying-
didn't need to reach
think
the issue.
That is what they were doing.
I do.
They did not say so. That's the point.
And they did not need to reach the issue to decide the case, because they also decided the pleadings were not sufficient to put PJT on notice.
I think the way I was thinking about this last time, you remind me in the Hecker issue, is, one, we're not bound by their characterization of which power they've exercised, and two, if we disagree with the exception, all that leaves is interest of justice. And I think that's what those other cases, Hecker and other cases, discuss. So if we disagree with their exception under the law, then it is an unpreserved issue, and then their decision has to be considered interest of justice by us, no matter how they've characterized it.
I think that's right.
Thank you.
Thank you.
Counsel, what do you say to the Hecker issue?
Your Honor, the first thing I say is I do think Hecker should at least be trimmed significantly, but I don't think you have to do that in this case to decide this case in favor of plaintiffs. I think Your Honor made one of the many different ways you can decide the case, which is that it was not the interest of justice. It was a different preservation exception that was being used.
What if we
But if
disagree
we-
with that?
Yeah, if we disagree that with their application of whatever interest, whatever preservation exception they thought applied, all we're left with, since we can't go back and replay the tape and go into their deliberations, we must assume that it was the interest of justice that was being used. That we have no other way of looking at it from this perspective.
But even in cases where you have found that it must have been interest of justice, and you've said we can't review that specific legal ruling, you've still found in cases like Feinberg and Brown that you do still have to review the ultimate corrective action. And here, the ultimate action was to dismiss the entire case. And as you did in Brown, you wrote, the only question properly before this court is whether the dismissal of the complaint was proper. And here,
Did
that's,
they say that they were exercising interest of justice, the appellate division?
in this case?
Correct.
No, Your Honor, they did not.
And with respect to a preservation exception, did the ruling support that instead? Ultimately, I understand, we can say that they made a mistake, but if, unlike in Hecker, wasn't raised, no exception offered, then one could come to the conclusion that it is, in fact, the interest of justice, because that's the only way one could have reached it. But here, it's different from Hecker, correct?
I think so, yes, Your Honor. Here you have the fact that it was a pure legal issue that, at least under the first appellate division's, arguably under the appellate division's precedence, there was no way to decide it other than how they decided it. That's an argument. But one other point
But are we arguing about an expansion of their articulation of what the duty is right here? Or isn't that what you're advocating for? They said the only people who come within the ambit of the duty are clients, customers, whatever they called them. And now you're saying, no, it's broader than that. So it seems to me as if there was some some argument that could have been made below on this issue had Supreme Court decided to take it up.
But here's the other point, Your Honor. I've not seen a Hecker decision that where the alleged failure to preserve was a failure to some making an argument in a reply brief. Because as we know, if you make an argument for the first time in a reply brief, the trial court has the power to say, I'm going to entertain it. I'm just going to give the other side a chance to address it at argument or with the surreply. Here, they presented it. In the case you guys...
Which seems to me, though, to be the argument for why the exception can't apply, because there were counter steps that could have been taken, but the court didn't give them an opportunity to do that.
But instead, Your Honor, in Henry versus New Jersey Transit that you decided two months ago, you said that only if it was presented in a trial court, at the trial court level, if you raised a specific argument in the Supreme Court and asked the court to conduct the analysis in the first instance, you avoid the Hecker problem. That happened here. The reason why the trial court chose not to deal with that argument was because it had a sufficient other legal grounds to dispose of the case. No different than if the defendants had raised this argument in their opening motion to dismiss brief and had gone all the way through and properly briefed it, and the court had nevertheless said, I'm going to dismiss the negligent supervision claim because you didn't sufficiently allege knowledge of propensity to commit this sort of an action. So here they raised this in the trial court. It would be even more unfair than Hecker for the court there, where the court there could have given us a chance to brief it, but said I don't even have to get to that, even though I was asked to, because I have an entirely independent legal grounds. Then it was fully briefed in the appellate division. That would be an expansion of Hecker, and I don't think the court
Well, I
has to.
kind of like that, but don't you not, aren't you aware of that after the decision of the trial court?
Well, Your Honor,
Where's the opportunity? You mean if they had decided on that issue, you would have said, well, wait a minute, we didn't get a chance to brief it, we'd like to re-argue it, can you give us a chance for reconsideration, we want to put in papers on it?
if the court had ruled on that,
Yes.
if the court had decided, but the court wasn't obliged to rule on that because the court had an independent legal grounds for making the same ruling that the defendants were asking for. So this was presented to the trial court. The trial court had the opportunity, if they wanted to address that legal issue, to ask us to brief it, but the trial court
So
said...
any issue raised in a reply brief would, in your view, without any exception being necessary, be preserved for appellate review?
No, Your Honor.
So what's the distinction?
If an issue was raised in a reply brief and the court decides it in favor of the party raising it in the reply
But
brief...
No. At the trial court, I thought your point was they raised this in a reply brief,
Right.
right? And the trial court just didn't address it. But you think that's unfair because it was raised and the trial court had it before it. It goes up to the, and those are the facts here, right? It was raised in the reply.
It was raised in the reply, yes, Your Honor.
So now I think you're saying that's preserved for appellate review because otherwise it would be unfair.
It's not in a case where the trial court has the opportunity to give us a chance to
It's
address
raised
it.
in the reply
It was
brief.
raised in a reply brief. But the reason why the trial court didn't do that was because it didn't have to entertain that. It had a separate legal...
What would you have said? I mean, as the appellate division in the first department said, this is just a question of law,
But
correct?
wouldn't you
So
have
that-
said your
what-
new rule about this is like it's a
Prospective
prospective client within the ambit of the professional mandate of the firm?
We would have made the same argument that we made in front of the appellate division that we made up
But I
here.
thought legal counter steps don't include mere legal arguments, which is what you would have done.
Right.
I'm sorry, I missed that, Your Honor.
Well, the point about the legal counter steps doesn't include just pure legal argument, because you can make that at any point, like you're saying, at the AD.
You can theoretically make additional legal arguments at any point along the process.
But if the controlling precedent in the first department is there's no relationship,
That you have to have privity, yes, Your Honor. If that's the controlling precedent, then it's a fruitless exercise. My only point is, it would create a strange incentive for the trial court. The trial court is presented with a new argument and reply. It doesn't have to reach it because it's going to go the same way based on a different legal argument that was already made. That's even worse than Hecker. In Hecker, it was not argued at all in the trial court. And in the Henry versus New Jersey Transit, the key there was it's not a Hecker problem if it was presented to the trial court and asked to be reviewed. And here it was presented, asked to be
Henry,
reviewed.
about a change in the law, it's like trying to start to remember Henry. Wasn't that a change in the law?
I don't remember the exact, what Henry, I'm referring to the way that the rule was announced. I don't honestly, Your Honor,
I
remember.
think the issue was raising it in the trial court when the law had changed. So what did you have to raise in the trial court to preserve an issue that was later, I think, decided
It's a Supreme
Supreme
Court
Court
decision. It was a Supreme Court decision.
Right, okay. There are multiple cases that articulate the rule the same way, Your Honor, but if there's any other questions, thank you. Thank you for your time.
Wise choice.